Thank you, everyone, for being here today. My name is Jason DeSanto, and I'm a senior lecturer here at the Northwestern Pritzker School of Law. I teach in the areas of First Amendment and public advocacy. And today I am honored to be moderating an event that should have a fair amount of both. I think we're getting together at a time of what seems like critical national moment where we're having an extended discussion about moneyed interests, about corporate interests, having an outsized role in our lives, whether in the law, government, our politics, or even in our own personal lives. And of course, on the other side, we have the long-standing debate about our freedoms, particularly in this case, our freedom to speak, our freedom to listen, and answering the question of what it means to be a speaking and listening person, an active citizen within the American democracy. So today, should a corporation be able to speak? How? Why? When? And to what effect on us? And to what effect on our democracy? And also, lunch. So we're in the middle of a robust national discussion, and today I think will be an important part of that. And the reason for that is we're joined by two absolutely remarkable people, and it's my pleasure to introduce both of them right now. Let's start with Steve Brill. Steve Brill is a legend in our legal culture. A graduate of Yale Law School, he founded and ran Court TV and the American Lawyer magazine. He's written incisive books on America's schools, America's healthcare system, and America's war on terror. He's written for the New Yorker, Time, the New York Times Magazine, and Esquire. He's won the National Magazine Award for Public Service, and he's a regular expert analyst on NBC, CBS, and CNN. Currently, Steve teaches at Yale, where he founded the Yale Journalism Initiative. And never one to rest, he last year founded NewsGuard, which rates the legitimacy of online news sites. Please help me in welcoming the legendary Steve Brill. Next to Steve, and next to me, is my colleague and friend, Marty Redish. Put simply, Marty is one of the most important legal scholars in modern American legal history. A graduate of the Harvard Law School, he's a Lewis and Harriet Ansell Professor of Law and Public Policy here at Northwestern. He writes and teaches on a number of subjects, including constitutional law, and most importantly for today, the First Amendment. He's the author, in fact, of more than 100 articles and 17 books. Those include The Adversary, First Amendment, and Money Talks, Speech, Economic Power, and the Values of Democracy. For these efforts, Marty has been recognized by the Institute of Scientific Information for being among the most highly cited researchers around the world. And beyond all that, he has won virtually every teaching award that we have here at Northwestern and continues as senior counsel at Sidley Austin. Please help me in welcoming the legendary Marty Redish. Now, as it turns out, all of that work by Marty has drawn the attention of Steve, and that's why we're here today. In Steve's most recent book, the best-selling Tailspin, available wherever fine books are sold, including outside, he articulates a comprehensive critique of modern American democracy, particularly the role of corporations within our democracy. And as part of that critique, and featured as a prominent cause of the American tailspin, not a good thing, is the First Amendment scholarship of Marty Redish, particularly in the fields of commercial and corporate speech. Now, to be clear, Steve interviewed Marty for the book, he quotes Marty in the book, and he disagrees with him vehemently within the book. And here they are today, side by side, two friendly foes at a fireside. In short, Steve's here because Marty's here, Marty's here because Steve's here, and we're all here because Marty and Steve are here. So here's how we're going to proceed. I will ask each of them a series of questions. They will also pose a question or two to each other, and then we will open it up to you to continue our freewheeling discussion with questions of your own. But first, we've asked each of them to provide a brief overview, a few minutes of their positions on the issues that we're going to discuss today. And we're going to start with Steve Brill. Steve.
Thank you. Is this on? Thank you, and thank you for having me. There's going to be a problem with this debate, and that is that it's going to be different from the political climate and the climate of debate that, unfortunately, we've got used to in this country. We both respect each other. I think he's a really smart guy. He's also a really nice guy. He was patient with me when I was doing the book. He spent inordinate amounts of time with me, enough times so that he was able to hang himself in the book. And we do really respect each other's positions. In addition, I think most of his legal analysis is not only correct, but it's trailblazing. It's just that the trail that got blazed has helped to destroy this country. So let me tell you what I mean by that. This conversation is not simply about the role of corporate speech, but also the role of money in politics. And the chapter in which I make the case for Marty Redish having been one of a half a dozen of the most influential people in destroying this country as we know it, that chapter opens with a scene in which I am sitting with a member of Congress, a highly regarded member of Congress, who is in a windowless room in an office building, not even an office building, kind of a brownstone house, about 200 yards from the Capitol building. He is sitting there, and as he's sitting there, he's on the phone. An aide is handing him slips of paper in which the name of the person who another aide has dialed on their phone. The name of the person is listed, the name of their spouse, their children, the background, the last time he talked to the person. And he is on the phone asking those people for money. He spends 5 hours a day, every weekday, doing that. And as I'm watching him, I notice that there's a lamp right over the desk. And he has in his handwriting a handwritten note that's posted to the lamp. And the note says, "I don't give a shit." And I asked him, I said, well, what is that about? He said, well, I have to remind myself, I have to be disciplined. We have to make as many of these calls as possible, as fast as possible. I've got to get the money. I've got to do this. I have to be focused. I cannot give a shit. And I said, well, what do you mean by that? So he said, well, for example, the other day I called a guy who has given me lots of money in the past, and I asked him how he was, and he said, well, I'm fine, but Lucille died. And Lucille is his wife. And he says, the congressman says to me, he says, oh my God. I said, Lucille died, that's awful. She was a great person. And the guy said, yeah, she was. And then I said, that's really awful, but the filing period for this quarter is Friday. Is there any chance you could write me a check today? He says, that's what I mean by I don't give a shit. And again, this is a typical member of Congress, absolutely typical. 5 hours, 6 hours a day, 5 days a week. That is the life that he lives. That cannot be what the founding fathers had in mind. And the reason that he is holed up like that is the result of the trailblazing work that Marty did. We'll talk about corporate speech in a little while. So I asked Marty about this during one of our interviews, and one of the things that I teach my students in the journalism class I teach at Yale is you have to be willing to ask people hard questions. Well, the way I decided to ask him this hard question was I took him to dinner at a nice restaurant. We were having drinks, and I told him the story I just told you about the congressman. And his response, and I said, don't you feel bad about that? You really think that's the way this country is supposed to be run? And he said, well, maybe if he was a better congressman, he wouldn't need to do that. Now that is absurd, because first of all, it's most members of Congress, and second, it has nothing to do with being a good congressman or a bad congressman. In fact, if you're a good congressman, You don't spend 5 hours a day every weekday of your life dialing for dollars. You attend to the country's business, but you can't do that because you have to raise the money. So that's what my friend here has contributed in the political sphere. On the corporate sphere, Marty very smartly took advantage of the case, and when I say took advantage, I mean it, I actually mean it as a compliment. Took advantage of a case brought by Ralph Nader that got to the Supreme Court in 1976, I think it was. And that case involved the ability of discount drugstores in Virginia who wanted to advertise that they were offering discounts on drugs, on the prescription drugs. And the established drugstores in Virginia had lobbied about the law passed in the state of Virginia that said you cannot advertise the price of prescription drugs. And the suit that Nader brought said, well, the First Amendment is for listeners as well as for speakers, which, by the way, was an argument first laid out by Marty in the thesis that he wrote that turned into a law review article in 1971, sorry. So they made this argument that we ought to be able to advertise our discount drugs. And the Supreme Court said, you're right. The First Amendment counts as much for listeners as it does for speakers. In this case, the listeners are the people, and the court veered out of its way to say, including the elderly and the poor, who will now know that they can buy drugs at a discount. That's what the First Amendment is supposed to be about. The fact that this is a corporation should have nothing to do with it. It doesn't matter who the speaker is, it matters that there's a benefit to the listener. Morph to, or cut to, right now, and the same argument is being used by Sidley Austin often and by Marty often to allow drug companies to market their prescription drugs off-label in a way that has been shown in multiple court cases, in multiple court actions all around the country to deform people, to kill people. But the drug companies are actually claiming, guess what, a First Amendment right to speak. And that speech is off-label marketing of drugs. With that generous introduction.
Thank you, Stephen, and thank you for coming. And I'm willing to discount a lot of your mistakes because you went to Yale Law School. And that explains.
That's a very good idea, right?
First, I want to welcome all the alums who are here. For so many of you, I have the strange urge to give a lecture about the Erie Doctrine. Many of you don't look prepared, so Steve wrote an article, a cover story of Time magazine about the time his book came out, an article entitled How My Generation Broke America. And of course, I'm right in there, right next to the guy who's responsible for the 2008 real estate crash. And as an old-time civil procedure professor...
You forgot Newt Gingrich.
Newt and I was like the whole thing. I reassociated to the old story about the defendant's response to a complaint where it was alleged that he had borrowed a pot from the plaintiff and returned it broken. And the defendant had three responses. One, I never had the pot. Two, I didn't break it when I had it. And three, it was broken when I got it. And I said, that fits for me breaking America. One, I never had America. Two, I didn't break it when I had it. And three, it was broken when I got it. Steve's fundamental mistake is to mix constitutional apples with political oranges. And as much as I tried to tutor him in all our exchanges, the message fell on deaf ears. So I need you to work with me on this. I want you to think in terms of a metaphor that I refer to as turning into the skid. When you're skidding on ice, your instinct, your emotive instinct, your first intellectual instinct is to turn away from the skid. You learn in driver's ed that that's the worst thing you can do. You have to overcome your initial intuition and turn away from the skid. And what I want you to do today is turn into the skid. You need to ignore what your emotional reactions are about what speech you like and what speech you don't like, and intellectualize it to see it through a much deeper, broader lens. Now, I use that metaphor when I go speak on the road, but I have to be careful because I used it at the University of Florida last year, and the student raised his hand and said, "What's ice?" But thankfully, I don't have that problem with this crowd because you're all in this situation. And the message you need to understand, and that Steve didn't, was that the First Amendment is not a strategic outgrowth of your political ideology. Steve says the results of my theory have been to cause harm. I'm not totally in disagreement with that, but that's not really the issue. Steve describes my theories in some detail, and he gets about 90% right, which is an A-, that's a good. But he never says, and he can correct me if I'm wrong on this, he never says anything critical about the actual theory, just about the political results. And that is not the way you can measure the First Amendment. To illustrate this,
This is the whole point of the book. The book says at the end, we need to change the First Amendment. I said you were right about the First Amendment. Why don't you take yes for an answer?
that is what I was saying. And I'm saying, therefore, since I'm right about the First Amendment, the stuff that flows from the First Amendment doesn't matter.
It matters if it's bad, and that's why you need to fix the First Amendment.
Let's let Marty finish his discussion of ethics, ice, and other metaphors.
Yes.
And then we'll go back and forth.
I'm sure Steve and I would agree that neither of us likes communists. Both of us, I'm sure, would defend the First Amendment rights of communists. I'll tell you a story about my former colleague and great friend Steve Presser. When that book, Money Talks, came out, I gave Steve a copy, a personal inscription, and put it in his mailbox. Now, Steve, a wonderful scholar, a great guy, the most right-wing human being I've ever met. He thought Genghis Khan was a left-wing radical. He sent me an email. And you think he'd say, "Congratulations, Marty, good luck with the book"? No, one line. "Redish, I always knew you were a closet Republican." Now, I headed students for Franklin Roosevelt 20 years after his death. I mean, the only time I ever voted Republican was when I wrote in the name of Abraham Lincoln in an Illinois gubernatorial race, thinking that 130 years dead, he'd be better than either of the two choices. So I wrote Steve a response, trying to teach him something about First Amendment theory. I said, the fact that I defend the free speech rights of corporations and commercial advertisers no more means that I'm a Republican than the fact that people defended the free speech rights of communists in the 1950s meant they were communists. And he wrote me back again, one line, said, "Weren't they?" I never had the guts to ask, "Steve, was that a joke? Are you serious?" But that's really the problem. Steve's criticism of me is for neutrally, logically applying coherent First Amendment theory in a way that has political results. Political results Steve doesn't like. There are other people who like them. I mean, don't Republicans have this tinkle-down theory or something? I'm not a big fan of it, but there are different theories. What Steve is doing is putting the First Amendment through his lens. It has to be changed to reach political results he likes. That kind of solar system is not going to work in First Amendment theory.
Oh, okay, and that was full bore Redish. No question about that. So I'm going to give Steve a chance to respond to that, and I want to pull back and I want to talk about theory a little bit, so everybody's clear on what your theory is, and then we can look at what the effects are. Right? So
I would have hoped that, I actually hope the professor would have read all the way through my book. But what I'm saying is, there are results I don't like. I do not like the result that members of Congress, Democrats and Republicans, have to spend 5 hours a day being obsessed with money. That's not a partisan dislike.
What's your alternative?
What's my alternative? Is a constitutional amendment that limits the amount of money that can be contributed on behalf of a federal candidate or by a federal candidate to his or her campaign. It's fairly straightforward.
That's why they have to spend so much
The
time.
amount and Part B, and the amount that the candidate can spend. Okay? That is a constitutional amendment that was introduced by Bill Bradley, I think, in 1992.
So you want to reduce the amount of information and opinion you can get in a political campaign.
I didn't say that.
Okay, all right, so let's go back to
That is half of it. Now, as for corporate speak, you...
advertising is largely what you're concerned with when you call it corporate speech, correct?
I call it corporate speech. The result that comes from the Supreme Court had, when it first enumerated the rights and the limited rights of chartered corporations, your position results in every single regulation related to commerce being challengeable on a strict scrutiny basis.
What?
Which part? If you'd like, I'll speak slowly.
No, I heard you. It wasn't that kind of a what.
The W.
So every single regulation of commerce is a regulation of speech. Is that what you're saying?
Most commerce is conducted with words.
So is a bank robbery. That doesn't mean bank robberies are speech.
Well, I'm not so sure if I follow your reasoning that it doesn't end it up there.
Nothing in my reasoning says that. You need to go back and read my stuff.
Okay, let's start there, okay? As Steve points out in the book, as many people here know, some may not, this discussion begins back in 1971 with an article he wrote, which was published in the George Washington Law Review, about commercial speech. By any measure, a groundbreaking article. In Steve's view, it blows open the doors to corporate domination. Tell us a little bit about the article, why you wrote it, and what your theory was, and then we'll talk about how that became actual First Amendment law.
Well, I wrote it because I wanted to become an academic. And that's one thing in the book Steve quotes correctly. Every Harvard third-year student had to write a thesis. And I knew I was aiming towards academia, and I wanted to write a man bites dog thesis. I wanted to take established free speech theory and shove it right back in the face of those who didn't understand the implications of it. At the time I wrote, commercial advertising or commercial speech had been disposed of as a matter of First Amendment protection in a 1943 decision in a matter of 2 paragraphs, and nobody ever questioned it.
No protection for commercial speech.
Nobody even gave it a thought. In fact, when I wrote this paper, it was very controversial at Harvard. People keyed my car, they pushed me into the locker. That was just the professor.
I feel like maybe you'd use that line.
It's new to them.
And that is a theory of teaching.
I began with a famous free speech philosopher of the 1940s, 50s, and even into his 90s and the 60s, Alexander Meiklejohn. Alexander Meiklejohn is the only free speech scholar ever to have his face on the cover of Time magazine because he battled Joe McCarthy extensively. Meiklejohn said, in his words, free speech springs from the necessities of self-government. He said, in a democratic society, the people we call the governors aren't really the governors, they're our agents. We are the governors. When we go into the voting booth, we are exercising our governmental function. And in order to facilitate that self-governing function, the voters, the governors, need a free flow of speech and communication. So what Meiklejohn said was, all that matters. Steve gets this wrong in his book. He says that Meiklejohn says, we need listener rights as much as we need speaker rights. Actually, that's wrong. Meiklejohn said, no speaker rights. All that matters are listener rights. The First Amendment is about the listener. Now, he ended up limiting speech protection to political speech because the self-governing process was simply in the voting booth. I took his theory and turned it right back on him. He was dead at the time, so I don't pay in doing this. But I said, you're right, Dr. Mickeljohn, that free speech is about facilitating self-government, but you're defining the concept of self-government much too narrowly. There is a private form of self-government, that when people make commercial purchases, they are governing their own private lives. Now where they have 100% of the decision-making, not just 1/1,000,000th in the voting process. So I said, this private self-government shares the DNA of our political self-government, but it does so on steroids. So I said, given that, the First Amendment is significantly, if not exclusively, about the listener. Who the speaker is doesn't matter. The speaker can be, as my old friend Ed Baker from Penn, I used to fight about this, a robotic profit maximizer. It doesn't matter because the First Amendment is about the listener.
So, for example, in the modern setting, for example, a bot on Twitter. Under this theory of the First Amendment, that is perfectly protected speech because we don't have...
Well, it would depend on what they say. In other words, I'm not an absolutist.
Okay.
There could be compelling interests that are shown, but I wouldn't exclude them simply because they themselves aren't self-realizing. You self-realize, you develop as much by reading a book as by writing a book.
So the speech has some value, but could also be balanced against competing interests.
As could any speech. A human speech could be too.
Okay, so that was the theory that you put out there. And then 5 years later, in the case that Steve referenced, Virginia Board of Pharmacy, the court essentially adopted that theory and extended First Amendment rights to corporations who are, in essence, advertising, right? Under a self-government theory.
Okay. Can I just modify that a little? Profit-making corporations have had First Amendment protection for years. What do you think the New York Times is? At least it's aspirationally profit-making. If we take away the rights of corporations to have First Amendment rights, why do media corporations have First Amendment rights more than any other corporation? You can say, well, and Steve says in the book, well, their purpose is to communicate. That's not the purpose of other corporations. But and that's certainly right, but I don't see why it makes any difference. If the key is the listener, who cares what the motivation of the speaker is? Who cares what the nature of the speaker is? The Supreme Court said that First Amendment means speech should be uninhibited, robust, and wide open. And that was a case where the court adopted the Mickeljohn theory of the First Amendment.
New York Times.
New York Times versus Sullivan. The author of that opinion, Justice Brennan, 2 years later wrote an article entitled, in the Harvard Law Review, entitled "The First Amendment and the Mickeljohn Interpretation."
Oh, okay. So the court comes to that finding in 1976, and as the law develops, the court, even today, doesn't afford commercial speech quite the same protection that it affords so-called political speech or public concern.
It's pretty close.
It's getting closer over the years. There's still a little daylight between the two. But essentially, corporations who are proposing a commercial transaction, who are advertising, receive First Amendment protection for those advertisements. Steve, do you believe that's appropriate?
As I explained in the book, I think it's absolutely correct, absolutely appropriate, and I praised Marty in the book for staking out that ground. Where I think there's a difference, and where I think he's gone up the cliff, is that there is a difference between speech that is meant to be discourse, that's meant to be in the marketplace of ideas, and speech that can be regulated. For example, and I'm not saying that he disagrees with this, but if I'm a doctor and I give you bad medical advice, I'm speaking to you, but I can be sued for malpractice. So just the act of speech. And if I'm a hospital and I have a sign that says, exit here, and it turns out if you follow that sign that says exit here, you fall down an elevator shaft, that's speech, but obviously that kind of speech can be regulated. the place where people who disagree with Marty, such as Robert Post, the former dean of my law school, would argue with Marty, is that there is a difference between speech that is part of a commercial transaction or that is advocating that kind of transaction, such as false advertising or advertising in general, certain types of advertising, like advertising cigarettes across an elementary school. There's a difference between that kind of speech and the speech that is trying to engage in a debate, such as a sign, arguably outside an elementary school, that says, we believe that the law not allowing cigarettes to be advertised here is wrong.
In the later case, it's more political.
Yeah, but and that could be a sign that is put up, by a tobacco company. That would be okay, but if they're advocating the kind of transaction that traditionally and rightfully is regulated by any government, you can't just use the First Amendment to walk over that the way lots of his clients have been doing that.
Okay, so let's stop for a second. So just points of clarification and also, so first of all, just to be clear, false and deceptive, misleading advertising is not protected by the Constitution.
Well, if you listen to Marty Redish, because he thinks if it's a statement of opinion that turns out to be false, like in my opinion, if you take 2 aspirins a day, you will cure DeSanto.
Let's get there in a second, okay?
So
that's one point.
That's simply pathetic.
Okay, and we will get there. That's one point of clarification. But I actually hear you to be making 2 different points that you just made, Steve. One is that the speech may have value and should be protected up to a point when then it creates harms, when the advice is wrong and somebody becomes hurt. And that's a question of a harm principle. We can talk about that. The other is whether or not the speech actually has the same value. The two examples.
Is it meant to regulate a commercial transaction? Is it meant to regulate a governmental function? For example, a regulation, an IRS regulation that requires you to fill out, all 19 lines of my tax return. If you take his argument literally, and then remember that forced speech is the same, comes under the same protection.
The government cannot compel a speaker.
The government is compelling me to fill out line 18 of the tax return. They should now have to go to court and prove under strict scrutiny that I alone absolutely positively need to figure out line 17.
None of that has anything to do with commercial or corporate speech.
It has to do with the difference between regulating a transaction, or in this case, engaging in a transaction, and participating in the marketplace of ideas.
And Marty, before you jump in, Steve, take a second and articulate for folks the larger argument you make in the book about if this view of speech as you view Marty's scholarship leading to, where a series of regulatory situations would suddenly become challenges, First Amendment challenges, environmental disclosures, IRS disclosures.
I'm not articulating that view. I'm not smart enough to come up with it on my own. I am articulating the views of people like Dean Post at Yale, and pretty much like the mainstream of legal thought in this country.
And that creates
don't get carried away by parties.
You call these moats that corporate power would be used
to
to
conveniently constructed protection or moat around all different types of government regulation. It is violating my free speech not to be able to advertise cereals that are filled with sugar for children. His response to that is you should either ban those cereals or let the cereal makers speak.
Okay, he's saying basically that these corporations are weaponizing your research, your scholarship. What's your response?
There's a difference between regulating a transaction and regulating speech advocating a transaction. Conduct has very limited protection under the Constitution, basically substantive due process under the Fifth Amendment. Speech has significant protection under the First Amendment. It's not absolute. But advocacy of conduct, even advocacy of unlawful conduct, open promotion of criminal behavior has significant protection under the First Amendment. What we're talking about is truthful advocacy of lawful products that is sought to be regulated under the paternalistic theory that we can't trust people to make lawful decisions on the basis of free and open debate. That's really what they're saying. It's important to note how the Supreme Court has defined commercial speech. Commercial speech is not just speech about commercial products or services. It's speech that does no more than propose a commercial transaction. So if you're criticizing a commercial transaction, you have full First Amendment protection. If Ralph Nader attacks General Motors because the Chevy Corvair is dangerous, he has a full First Amendment right to do that. If Chevy or General Motors tries to defend itself to contribute to the debate by saying, let's assume truthfully, no, that's not accurate, they have less protection.
Where does that come? What are you talking about?
No, that's absolutely clear.
Which case said that?
Nike versus Caskey.
No,
Let's stick with. You asked me which case. I told you.
Let's stick with your hypothetical. You're saying that if Ralph Nader or some other name today said that a certain car was unsafe, and the car company could be barred by statute or regulation from saying, oh no, we're safe.
No, I say they get less protection. This was the case of Nike versus.
Which is the less protection that they would get? Could they take out ads and say, we have a safe car?
Not if it's an all false, they don't get protection. Ralph Nader gets protection of the New York Times reckless disregard knowledge of falsity standard. Nike versus Caskey was a case where CBS and New York Times had alleged that Nike had engaged in use of slave labor, sweatshop labor in foreign countries to prepare its sneakers. And Nike held a press conference to deny it. And somebody sued them in California alleging false advertising, saying this is commercial speech, which means if it's false, regardless of your knowledge of the falsity, it gets no protection.
So just to stop.
Well, I agree with you. You're totally right.
So we're done. Can I
You're totally right. I think they should have a right.
That it all flows in escape.
Just the way I think, just the way I think the cases that have been talked about against the oil companies for saying that, for denying climate change, that to me is First Amendment protected stuff.
I don't think you realize the implications of your own.
No, I think I do. Because what I'm saying is, I'm trying to narrow it down. I think we disagree in a very narrow place where you were frankly just way over the top and gone. And that is that the implication of what you're saying is that a tobacco company ought to be free to take out billboards across the street from an elementary school.
No, I never say that at all.
Why? If they have a right to advocate for their product.
Because speech aimed at children is on a different level. I've always said
So
that.
how does that explain the article you wrote attacking regulations against serial advertising on television and
You're obviously not familiar with some of the nuances of First Amendment doctrine.
They're getting speak solely.
I'll try. As long as you don't interrupt. The Supreme Court has held that while, as to obscenity, for example, children cannot be exposed to obscene publications, when the children are part of a broader population.
Oh, you mean so that parents can watch the ads? That's
Yes.
your argument, sorry.
Well, the Supreme Court said the First Amendment does not allow society to be reduced to the level of the sandbox. That's a direct quote from a major Supreme
In
Court.
other words, we're not going to regulate what kids can see necessarily in a way that prevents their parents from seeing something.
There's subtleties
That was
here.
the argument. No, that was the argument.
Okay, but essentially what you're arguing about is the degree of the harm. Marty's saying, I think they're both saying the speech has some degree of value. Marty's saying that when you advertise tobacco in front of a school, that there is some harm created. Your argument in the book is that there is a large-scale, massive harm that is being created, potentially, by the degree to which corporations will test every single
Well, that's
one of those
what's happening. That's what's happening.
okay. And one of those being prescription drugs,
Right.
right? One of those being the issue. I just happen to have these here today. I needed to put some Xanax in the middle of this debate. Fireside, excuse me, not a debate. But, Steve, can you articulate this controversy about marketing, advertising, off-label? In other words, drug companies wanting to market uses of their drugs which have not been FDA approved, and the FDA saying, that's illegal. You can't speak in that way. What is the controversy?
So here's the summary of the argument.
Okay.
When the FDA came into being and got the authority to regulate, to approve and then regulate the marketing of prescription drugs, they said you can only market it for the use for which you ran all your trials and did all your research and submitted all your research and for which we approved it. So if drug A is good for thyroid cancer, that's how they got the approval, you then can't go and market it and say, hey, it's also really a terrific for throat cancer because you haven't gone through the elaborate process to make sure it's okay for throat cancer, that the side effects aren't more dangerous than the potential upside, et cetera, et cetera. It would eliminate the incentive to go through trials for everything else. Once you got it approved for one thing, we wouldn't have to worry about marketing it for all the other things. On the other side, though, is the very real benefit that has often come from doctors prescribing drugs off-label. The best example is aspirin. No one ever thought of aspirin as a way to prevent a heart attack or stroke. But there are a zillion other examples where doctors have experimented, and the FDA does not govern the conduct of doctors. So a doctor can say that the thyroid cancer drug, I have reason to believe that it's worth a try. If you have a different kind of cancer, I'm going to prescribe it for you, and that's totally legal. The question becomes, how much does the drug company encourage the doctor to use it for these off-label uses, which very often will have a larger market than the original use? And where they came down was a compromise that Marty believes rightly is inelegant at best, which is, okay, you can do it, you can, we will let doctors prescribe this for off-label, unapproved uses, but you, the drug companies, you can't really market them and push them to do this. And if you do, it has to be under really controlled circumstances, because otherwise the whole system we have will go haywire.
So they have a regulatory power, the powers to provide for safety. They only have it over the drug companies. So they say to the drug companies, do not encourage the doctors.
And the fight over this, and this really goes into Marty's wheelhouse, because the fight over this is whether a drug company can speak to arguably the most sophisticated listeners in the world and say, here's why we think you should use this drug for throat cancer.
Doctors.
Yeah. So why shouldn't those listeners of all people, why shouldn't they have the right to get that information? Because what if it works for throat cancer? And again, the argument on the other side is that if you can do that, you would just get the drug approved for some narrow use, and then you go to town and you market it to all different kinds of doctors for all different kinds of things, which in fact is what happened. I wrote a long series about Johnson & Johnson marketing a drug called Risperdal, and when the FDA approved the drug, the FDA said, this is a good antipsychotic, but whatever you do, don't market it to children or the elderly, because it will cause deformities in children, and it will cause strokes in the elderly. And Johnson & Johnson, this has been proven multiple times in court, and Johnson & Johnson, of course, set up a pediatric sales unit and an elder care sales unit. And it turned out all this material, they hired all these doctors as consultants who conducted the seminars and explained why this is a great drug for the elderly and a great drug for ADD in children. It caused thousands and tens of thousands of deformities in children, tens of thousands of strokes in the elderly. Johnson & Johnson paid billions of dollars in fines, pled guilty to a crime, and the lawsuits are still going. And now, and the Johnson & Johnson board took the argument. They didn't want the lawyers to settle because they said, in our opinion, we think this stuff really works for children. It's great for ADD. These kids will behave.
And we have a First Amendment right and should be able to.
We have a First Amendment right, and the listeners are doctors. So what's the problem?
All right, Marty, that sounds predatory, dangerous, the kind of harm that you identify.
He just said it's predatory.
Well, I'm going to give you a chance to respond to that. It sounds like the kind of harm that you were saying a few minutes ago that we might think about, no matter what the value of speech is to listeners, the harm outweighs the value of the speech. Why not?
Okay, first, as doctrinal fact, in 1996, 44 liquor market case. The Supreme Court, in an opinion by somebody who studied classes in this room, Justice Stevens, says the First Amendment prohibits the restriction of truthful advertising for a lawful product out of the fear that people will make wrong lawful decisions. That is controlling doctrine. Now, as to off-label advertising. Drugs are approved usually for one particular purpose. And it takes quite a bit to get a drug approved. And a lot of studies, a lot of statistical results, and it's very expensive. However, it early on became clear that drugs often had benefits that went well beyond the particular function it was approved for. If government wanted to, it could prohibit, make a crime, all off-label uses. But they won't do that because, as the FDA itself acknowledges, some of the most important cancer treatments are off-label. But what they do instead is swim halfway across a river. They don't prohibit it. It's perfectly legal for doctors to recommend off-label uses because they are very often life-saving. But they won't let the drug companies tell the doctors about this. And do we assume the doctors are going to know it? Well, maybe some will. But particularly in rural areas, the doctors may not know it. Their patients will die because they weren't aware of this off-label use. Now, are there situations, I don't know the Respirol situation, I wasn't hired for that one. But let me assume, for purpose of argument, then there are clearly exceptions. But the FDA is using a hatchet instead of a scalpel. They're prohibiting all off-label advertising without any inquiry into whether the use it's being suggested for is well accepted and extremely beneficial, or what I guess would be the relatively rare case, something like this. We're basically allowing them to take the dolphins in with the tuna. And that's anathema to what the First Amendment's about. That's the classic illustration of overbreadth, of First Amendment overbreadth, because there are some situations where the device of off-label advertising is being used improperly. We'll prohibit all of it. And every court that's had the chance to deal with it, the drug companies are scared to tangle with the FDA on this, but when they occasionally have, every lower court has found this unconstitutional. And I'm proud to say that the Second Circuit in the Coronia case relied in large part on something I wrote for that conclusion. And the government never takes these cases to the Supreme Court because they know they'll lose just like that. Because what they're doing is blatantly unconstitutional. Instead, they keep bullying the drug companies to deter them from engaging in truthful speech for lawful conduct. Are there exceptions? I'm sure there are. Then regulate the exceptions. Earn your money.
Well, first of all, let's talk about the exceptions. 8 of the 9 largest drug companies on this planet have pled guilty and paid billions of dollars in fines for the same violations that I just referred to with Johnson & Johnson. 8 of the 9. Okay, those are not exceptions. And in, I think, 6 of them, it was multiple drugs. So those are not exceptions. The drug companies are allowed to do a certain kind of limited off-label marketing. If a disinterested doctor, someone not on the drug company's payroll, writes an article based on a disinterested clinical study, the drug company is allowed to send that article around to doctors. They are allowed to do the limited advertising that you're talking about. And also, let's not spend too much time on how expensive the process is and how they need to shortcut it because it's so expensive. The pharmaceutical companies in this country as an industry, and also each of them individually, have the highest profit margins, the highest gross profit margins, the highest net profit margins of any industry in this country. We think Google and Facebook have high profit margins. Every major drug company has a higher profit margin than Google and Facebook. So whenever they're spending to go through these arduous trials, it's kind of working out okay.
First of all, I think you need
I'm going to give you the last word here.
Yeah, you need to check the literature on how widespread valuable off-label uses are. To tell me every drug company has had this situation arise is not to tell me those aren't exceptions. There are thousands and thousands of valuable off-label uses. And if they want to, if the government wants to require every use to be on-label, to make it criminal to engage in off-label uses, they can. They have that power. That doesn't regulate, infringe the First Amendment. But they don't want to because they're so important. Yet they won't let doctors find out about it, except in the limited situation you're talking about. Was the compromise settlement in the Washington Legal Foundation case. But the government didn't even want to allow that. It was sort of forced into it by the district court in Washington.
I have no doubt that you're right that the way the courts are currently constituted, the government will lose these cases. The government's strategy, as I point out in the book, was they were sort of holding in abeyance, going back to the federal courts to deal with this, waiting for President Clinton to either appoint Justice Garland or President Justice Garland. Yes, President Hillary Clinton, and that kind of didn't work out. So
Justice Stevens was one of the most liberal justices on the court, and he still wrote the opinion in 44 Livermore.
Okay, all right. So let's more briefly than I would have liked, but we've explored a lot here about what we might call advertising or marketing. I want to move to campaign finance specifically, and I'll simply just quote some numbers at the beginning regarding money in politics, which is where Steve started us off. In the 2016 presidential election, Hillary Clinton and the Democratic National Committee spent $931 million. Donald Trump and the Republican National Committee spent $648 million. In the 2018 midterms, just for House races, which we're in right now, the Democrats have raised and spent $850 million, and the Republicans $576 million. In the Illinois governor's race that we're currently involved in, $240 million combined have been spent by the two plebeians who are running for governor here in Illinois. Now, all of these numbers are without outside money groups like super PACs, dark money groups, 501c4s. These are simply party money and candidate money. In the book, Steve, you describe a parade of horribles. You started off talking about who you call Congressman Jones and the I don't give a shit theory of fundraising. You also talk about then Congressman, now Arizona Senate candidate Christine Sinema, who is known for triple dialing skills.
Triple dials for dollars. She has 3 cell phones held up. She talks to someone that gets the next one, that gets the next one. She's a legend in Congress.
She's a genius of fundraising. But a much larger issue about the way that the raising of money creates terrible incentives, that the establishment of political action committees has created an unvirtuous circle of lobbyists putting money into political action committees or other independent groups or directly contributing to candidates. Those candidates who then go into Congress and serve on committees that, of course, are going to have something to do with the legislation that the person who gave the money is interested in. and a whole other group of problems, including gerrymandering, the loss of party control, and the rise of fundraising in primaries, so that in the districts in America, which are the 40 or 50 U.S. House districts that are truly contested, what matters most is the primary. More money is poured into the primary. Candidates continue to move further and further away on the political spectrum to attract that money. Many of these things have been chronicled in places other than your book, but you do a thoughtful and some would say devastating effort at putting them together. All of this rests on the Supreme Court in 1976, another 1976 decision called Buckley versus Valeo, which established the premise that money is speech, and that money and the raising of money and the spending of money is a First Amendment protected right. That too grows out of Marty's scholarship. So the first question I have for Marty is, are you disturbed by any of what I've described here or what Steve has described in his book?
Certainly I'm disturbed, and I was disturbed when Nazis were allowed to march in Skokie, and I had no doubt that the First Amendment protected it. In the Federalist Papers, James Madison once said, sometimes the cure is worse than the disease. And I don't dispute that this is problematic, though I think there are technological advancements that are softening this, raising money by the internet, putting things on YouTube, which give avenues for people who don't have money that weren't a problem weren't available back in the 1970s. But of course, money is speech. If Congress passes a law saying the New York Times can publish anything it wants, it just can't pay for newsprint, it can't pay its workers, it can't pay for machinery to publish, that is an infringement on their First Amendment rights, because money is essential to communicate. Even poster board and markers cost money. And to the extent you limit the amount of money involved, you are decreasing the flow of information, and we have no reason to assume ex ante that this information is false or misleading or defamatory. We can assume that this is perfectly truthful information, yet because of an attempt to produce some kind of race to the bottom equality, we're going to restrict it. Well, let me tell you a law that would satisfy equality. A law that says no one can say anything about anything, ever, anywhere. That's completely equal. It satisfies any equality requirement. But it obviously shows that the First Amendment is about a lot more than equality. And the more you restrict communication, the more you're interfering with, or the more you restrict the money, the more you restrict the communication. Now, some of the figures you read show that Hillary Clinton far outspent Donald Trump.
This is true.
And she lost. I know that might come as a shock. She lost. The candidate that spends the most does not always win. Donald Trump didn't use money, he used celebrity. And money can be used to equal out celebrity. Are there harmful consequences from this? Absolutely. But I consider the cure a lot worse than the disease.
Steve?
Well, did you actually just say that the alternative is nobody saying anything about anything?
No, I didn't say that. I used that as a construct to make a point that the First Amendment is about more than just a law.
So let's come back to the beginning of the chapter. You got that congressman, 5 hours a day, like every other congressman. It's not whether raising the most money gets you the most votes, although in Hillary Clinton's case it did. It's not whether...
I see what you did there.
It's the obsession with money. It's how money drives the agenda totally. What this guy does every night, he does every weekday night, as you know, because it's a few pages later in the book, he goes to cocktail parties that are fundraisers. And lobbyists come to talk to him about the committees he's on because they've contributed, and that's how they get to go to the cocktail party. It is the obsession with money. The influence flows from money in politics. That is not a good thing. I happen to think, as a matter of legal analysis, you're completely right. I think that Citizens United was decided, actually, the way the law dictated that it should have been decided. I think they went a little overboard in the breadth of the decision.
Just to be clear, people leave with nothing else today. They're clear on what Citizens United decided.
Well, let's remember what it didn't decide. It had nothing to do with individual rich people giving money to campaigns or giving money to PACs or indirectly supporting a candidate.
What it dealt with was independent expenditures.
It took the
On
limits
behalf of
off of
campaigns.
independent expenditures by corporations. And it didn't really have to do that because it could have said, as Marty points out, Citizens United was a media operation. They had produced a documentary about Hillary Clinton, which is no different than if they had produced, the MSNBC producing a documentary that was, critical of Donald Trump. The FEC decided that because it was these people, that they were giving Hillary Clinton an illegal campaign contribution by producing that documentary, which was absurd. They could have decided that case on narrow grounds. But Citizens United isn't the issue. The issue is whether it's a corporation or an individual, whether it's Jim Steyer, Tom Steyer, or the Koch brothers. It's the same issue, and it's the same issue if it's a corporation or not, and that is the undue influence that unlimited expenditures and unlimited contributions have on our elections process. There is no denying that. The way I think you have to deal with it, because he's ultimately right on the law, is you need to honor the First Amendment by amending the First Amendment.
Okay, let's stop. And I just want to say to everybody, if you have questions, we've got 2 microphones set up down there at the bottom. We'll have time for a few of your questions, so feel free to come on down if you want to ask anything else that we haven't gotten to today. There's probably plenty of that. Marty, I want to ask you a question, though. I want to ask you, first of all, you mentioned money as speech. I'll just say parenthetically, Justice Stevens, who you have cited prudently earlier today, has argued that Buckley was a mistake and that money is not speech. And after he retired from the bench, he has been adamant in saying that money shouldn't have been considered speech. But just in case, he would advocate for what Steve has advocated for, which is an amendment, essentially, to the First Amendment, another constitutional amendment which would allow Congress to regulate the amount of money into campaigns. And that's one point.
Which is what Senator Bradley introduced.
And that went, of course, really nowhere. The premise of Citizens United is that there was no coordination between these independent groups that are unlimited. What the court said was, there's no risk of corruption, and what we're concerned about is corruption. And corruption to us is you give a campaign money, and the campaign and the candidate do something because they got the money. That's what we're afraid of. And we're afraid of the appearance of that. So we are going to allow Congress to regulate the amount of contribution you give to the campaign. That's still constitutional to do. There's no First Amendment issue. However, if an organization is going to spend independently on behalf of a campaign, there's no risk of corruption, because they never give money to the campaign. They just go on their own and they spend money independently. What the court said is, as long as that's what's happening, there's no risk to corruption, so they ought to be able to spend as much as they want. That's actually what Buckley said. And here in Citizens United, we're just building on it and saying it's a corporation that can do that, or a union that can do that. But the premise of all of that is that there is no coordination. There's no connection between the independent expenditure group and the campaign. Now, according to the Federal Election Commission, this is what constitutes no coordination. Showing up at a fundraiser for your own super PAC, as Barack Obama did in 2012. Having your former campaign advisors go up and run a super PAC on your behalf, which advisors to Barack Obama did in 2012, and a whole host of others. You can even use the same consultants as long as they have a quote-unquote wall set up within their advertising agencies so that they never talk to each other. That doesn't sound uncoordinated. Those sound pretty coordinated. And it is almost always true, as Justice Stevens said in the dissent to Citizens United, that members of Congress know who is running the super PACs, know who is putting money into the super PACs, and who is essentially trying to help their election, even if they never talk to them. Now, does any of that give you pause? Not, assuming money is speech, so it has value, that there might be some harm to the democratic process.
Okay, first of all, I want to emphasize what you said applies to non-corporate associations and individuals. That's not a unique corporation concern.
Okay.
Secondly, as I understand it, the concern isn't corruption as a result of coordination. It would constitute a contribution in case of coordination that goes above the limit of the contribution.
But the reason for the contribution limit being constitutional, the reason that the court has said that the First Amendment does not stop Congress from regulating contributions, is that there is a compelling interest in making sure that there is no corruption.
Not totally. They also said that contributions are a reduced form of expression. And when you make a contribution, it's a diluted, indirect,
attenuated.
Yeah, and that got them to test it by a lower standard.
Wait. The most naive and oft-quoted part of Justice Kennedy's opinion was that there's no evidence that these kind of independent expenditures won't be independent and therefore won't be susceptible to the corruption that we're all worried about. I mean, that's just a joke today. There isn't anyone who can do that and not say he was wrong.
No, I think that was a simplistic overstatement. The question really is, what are the consequences? If we're talking about private individuals imposing limits on what they can spend to make their own statements, I think we're in significant trouble. If you limit what a candidate says, and a candidate has spent her limit, and a new 9/11 happens, then what? They can't take out advertising to say what their position is on what to do at that point. I think you're grossly underestimating the serious corruption of the expressive process by putting these artificial financial limits on how much candidates can spend to communicate and perform the democratic function.
I gotta tell you, I just don't know what bubble you're living in, but you are, because look at the system we have today. And by the way, if another 9/11 happened and someone was running for president, the odds are a lot of cameras and microphones would show up and ask her what they thought about it. We'd have to spend
They have to count on that.
Well,
They can't take out the ads.
if you're running and you don't, a lot of people who run and who aren't the kinds of people who can raise money for large corporations and lobbies count on being able to get on free media. Yeah, that's true. And maybe you don't like that. That is true. And again, just look at what we have today. How can anybody sitting in this room look at what we have today and say, yeah, that's good? And I'm not saying we should sacrifice the First Amendment for it. I'm saying that in a very specific area of elections, of campaigns, not expression. And by the way, this is not a perfect solution, because 100 people independently could decide to spend a lot of money to support a candidate. It's not a perfect solution, but it is a way to get that guy out of that little windowless room and get him back to work being a legislator.
Who wants to work less, tell him to become a law professor.
Okay, I'm going to ask each of you one question.
Sure.
I'm going to ask each of you one question on this subject to close it out. Marty, recently, during the nomination controversy involving Brett Kavanaugh, that went on for some time, and finally on Saturday it came to a final vote. And when I turned on the TV that day, the thing that I was struck by was that nearly every single senator was sitting in the U.S. Senate. I visit Washington occasionally. I'm sure people here have. I'm sure we have people here who work there. And they will know, as I know, that is a very rare occasion. The most likely thing to find when you walk into the U.S. Senate, the United States House of Representatives, is about 4 people in the entire chamber on the floor. Everyone else is either in perhaps committee or they are out dialing for dollars. Does it not worry you that 4 to 5 hours a day of what elected officials are doing is trying to get elected by raising money because they are deathly afraid of being primary and crushed by a super PAC in the last week of an election? Does it worry you that they are not on the floor, that the Mr. Smith goes to Washington is never going to happen? They are not talking to each other in this country. Does it not worry you that these people are not actually on the floor of the Senate debating issues? Or in committees where they can debate issues?
I think you're confusing cause and effect. The kind of situation you're talking about, very few people on the House or Senate floor, is not new. I remember 30 years ago reading an article about somebody in the gallery who was arrested because he started screaming, "What the hell is this?" Because nobody was doing anything. There were 5 people. Somebody
sure wasn't Steve.
We can check his prison record. Basically, what it comes down to, I remember when Lester Maddox was governor of Georgia, and he was asked about the problems in his prisons, and his response is, "We need a better class of prisoners." I think that's the answer. The quality of our office holders is very, very dubious. And the question again, Steve really hasn't given us chapter and verse. How much would the limit be? How would you determine it? How would you enforce it? Who would be affected by it? It's easy to say this is a bad system, but he's done precious little to tell us exactly in chapter and verse how we're going to replace that and still have a viable democracy where speech is uninhibited, robust, and widely.
Steve, I'm going to ask you a question.
Sure, that was a great non-answer.
What is the difference between, let's say, an independent expenditure group, a super PAC that wants to weigh in on an election, and the New York Times, which is a large corporation that weighs in on an election all the time? As long as we have some degree of disclosure, perhaps that's a different issue, of who's contributing to the large organization that is spending the money. It's just more ideas. And the New York Times or MSNBC or Fox News, they have a position. We understand what their bias is. We know how to interpret what it is that they're saying. They're putting a ton of money behind what they're saying. Is there any appreciable difference between those two very large-scale providers of information into the marketplace of ideas?
What you're describing is kind of an argument that says because we cannot solve this problem completely, we should not try to solve it at all. Obviously, you could pass a constitutional amendment in a manner in which Senator Bradley wrote it, which says Congress shall have the authority to regulate the amount of money that can be spent on behalf of a candidate for federal election by any group or person, and the amount of money that the campaign itself may spend. There will be lots of loopholes around that, but it does get to the core issue and the core problem. By the way, Congress could also pass a law saying, the way the states of South Carolina, miss a few, I think Minnesota, maybe South Dakota have done, which says you cannot be a registered lobbyist and contribute any money to any candidate for state office. Then the constitutionality of that has been upheld, or at least upheld until Marty finds a client who makes it okay with it.
I don't have one yet, so I'm okay.
Yeah, but I mean, there are things you can do, and it's not simply criminal. There are major things you can do, and let's remember, this is sort of like when I think about healthcare. The United States is lousy, incredibly lousy system in terms of cost and results versus every other developed country in the world. There are countries that have solved or have improved on this problem in some ways, in ways that Marty and I would both disagree with and vehemently object to, but in other ways in which we might actually think they make sense. the solution isn't simply to say, well, we've got a First Amendment, and therefore we're going to keep that guy in that room for 5 hours a day, and we're going to have a system where the people who get elected are the ones who go to the most cocktail parties with the most lobbyists. That is, you cannot tell me that when the founding fathers fought that Congress, that's what they had in mind they were going to do every day.
I don't know what the founding fathers thought, but did you ever see the way they dressed? I mean, did you really care what they thought?
I want to be back in Boston and get away with lines like that.
That's next week's debate.
My loss were only had lines like that.
Of the Sunshine Boys. Okay.
But can I just add, the problem that Steve is not recognizing is the danger of swimming halfway across a river. We can't cure all the problems, so we'll just cure some. You're not realizing you're expanding the problems by giving, in effect, an antitrust free pass to all the institutional media. They are unlimited, but nobody else can compete with them.
Now, just everybody here stop and think for a second about that metaphor, okay? That is one of those metaphors that always sounds true. It's the danger of swimming halfway across the river, and you can apply that to any effort to do anything other than completely solve a problem. It doesn't matter what it is. I mean, that's a perfectly meaningless metaphor.
I think the imagery is pretty strong.
All right, on that positive note of fellowship, nobody has any questions. I think we're going to bring things to a close.
Well, let's have some questions.
Here we go. Okay, good. I didn't see you there. Okay, go ahead.
I have a question on Professor Redish's listener rights theory of the First Amendment. So if we're looking at the First Amendment as about the listener's rights to hear information, doesn't that also entail the notion of like volume control? If someone is speaking so openly and unbridledly that the listener can't hear other voices, does that implicate First Amendment issues?
Yeah.
That's a good one.
He's a very good student. Although his brain just went down. No, Jacob, I've heard that argument, and again, it sounds good. What it's not realizing is that it really doesn't apply. Unless one speaker has spent so much that there literally is no opportunity for the other speakers to speak, there's no drowning out. Both speakers can speak. If you limit one speaker, that doesn't mean the other speaker is going to have more money to communicate. It means you've just made the public equally ignorant about both.
You notice how we turned your question totally around from the way you asked the question. In fact, I thought I was going to hear about swimming halfway across the river.
So you have one more there?
I guess so. I guess I have a question for Professor Brill. You're concerned about corruption in terms of money in politics, and Donald Trump spent about $15 per vote. Hillary Clinton spent about $20 per vote. Do you really think that convinced anybody, that much money spent on any one person? I mean, at the end of the day, they still have to go to the booth and pick whatever they wanted, right?
Well, I think the issue is the obsession around all the money that was raised and put up for all the candidates. And again, your Trump comparison of Clinton is not quite apt because the outside funds supporting Trump were much more.
No, that was it total with the...
By the way, I'll just remind everyone, among other things, that the Trump promised to finance his campaign completely. 100%, no one's going to have to give any money. We've forgotten about that. And the second point is, obviously Hillary got more votes than he did. And third, again, the issue isn't who wins and who loses. The issue is, if you have a campaign, let's say for Congress, which is happening now, where there are districts where people are raising $3-4 million each, $5 million each for Congress. If you have to do that, if you have to raise $5 million and you have 2 years to do it, because you run every 2 years, let's do the math. That's 100 weeks divided by $5 million. That's $50,000 a week you have to raise. That's $10,000 per weekday. It doesn't matter who wins or who loses. They're both doing that. We don't have a government.
I mean, we get a lot of laws passed.
Okay, all right. Good questions, thank you. Why don't we hear one over here?
Yes, to Professor Redish's point about the advertisements in schools and cigarettes in schools. For example, we don't allow cigarettes in schools. I don't know if things have changed, but when I went to school, we clearly had vending machines with Coke cans in school. And going off of this, it seems like that's clearly speech intended just for children and not their parents. Yet we ban cigarettes in school because of the harm to children, and because it would exclusively advertise to children. Isn't that, are we still in essence allowing corporations to advertise just to children by having those vending machines with Coke instead of Pepsi?
I think you're listening to Steve too much. Selling Coke in a Coke machine is not speech. That's conduct. And that can be prohibited by government if it wants to. It can be prohibited by the school if it wants to. When you put money in a Coke machine and take a Coke bottle out, that's not speech.
Thank you. All right, last question, then we're gonna wrap it up. I wish I'd seen you all up there sooner. If we'd have done this earlier. Okay, go for it.
Hi, I just have one question and one comment. So there's an argument that elections are a public good, and so therefore maybe we should just completely get rid of private interest in it and make it publicly funded. So what would the constitutional response to that be? And my note also is in many European countries actually they are, and you do still see a lot of lobbying influence. So even though they got rid of this, unlimited funding doesn't exist, members of parliament still spend a lot of time with lobbyists.
No comparison. I actually have a little bit of experience in this from the businesses I've run. There's no comparison. There's just no comparison.
Okay, how about public financing? Let's take that out.
I'd like to know what Steve thinks about it. Obviously, I think it's unconstitutional, but I'd like to see what Steve thinks about it.
Well, take a constitutional amendment for sure, and it's not one that I think would be terribly workable. Although it has worked in certain localities, based on complicated matching formulas and stuff like that. But purely, having a system that says it's purely public funding, and if Marty Redish wants to run for Congress and take the enormous wealth he's gathered here at this law school and pour it into his campaign and not be publicly funded, he has to be able to do that.
And we look forward to Steve Brill, campaign manager for Marty Redish, being part of